NACDL is the association of the nation's criminal defense bar.
It is my honor to moderate this panel with three individuals who unfortunately can tell us about their firsthand experiences in the trial penalty. As Monica said, the trial penalty, or rather getting rid of the trial penalty within our lifetime and sooner than that, is near and dear to my heart. I'm not a big fan of the trial penalty. I'm a big fan of getting rid of it. And NACDL has been doing yeoman's work, person's work over the last years, thanks in part to Norm and thanks in part to the staff. To some terrific vision and leadership. We are at the forefront of trying to reduce and get rid of the trial penalty, not 50 years from now, but in the next 5 or 10 years, because it is thoroughly unconstitutional and it has an impact on people's lives, on particularly people who are vulnerable, particularly people of color, and particularly the poor. So we need to do something about it. It is incumbent upon us, if we care about justice, to get rid of the trial penalty, and we are focused on doing that. One of the things that this panel today will help us remember, and Susan referred to it during the last panel, is that it's not just about going forward. It's also about reaching back to people who have already been impacted terribly, unconstitutionally, and inhumanely by the trial penalty. And the third panel today on the second look, with the second look focus, moderated by Jane Ann Murray, will do that as well. So it is my honor to introduce now the three panelists who will be speaking to you today about their firsthand experiences. So I'm going to look up, I'm going to read, because I'm going to make sure I don't forget anything here. Our first panelist is Chalana McFarland. She's a 2021 Presidential Executive Clemency recipient. She was freed after serving nearly 16 years in federal prison as a nonviolent first-time offender, 16 years. Prior to her incarceration, she practiced law in Atlanta, Georgia, where she lives now. After graduating from John Marshall Law School, she's a graduate of Florida A&M University, where she earned a bachelor's degree in journalism. Since her release, Chalana has become a vocal advocate for criminal justice and prison reform. She is a sought-after keynote speaker and I can say from having spoken to her, I can see why she's sought after. And she's author of an upcoming book called Unintended Consequences. She currently works as project manager for CAN-DO, C-A-N-DO Clemency, and serves on the advisory boards for Fighting for Freedom, Atlanta Incarcerated Art Project, and Atlanta Women on the Rise, which is a reentry initiative. Chalana was also tasked with serving on the Commutation and Pardons Work Group for the Justice Roundtable. She's appeared on NPR, StoryCorps, PBS NewsHour, A Neighbor's Choice, and The Roach Brown Show, and on Sirius and iHeartRadio. That's pretty impressive. She and her story have been featured in web stories on the ACLU and Vera Institute sites. She's the proud mother of a college junior, and again, she resides in Atlanta, Georgia. Robert Rose is a researcher with a focus on dismantling the prison industrial complex and working towards improving the lives of people currently incarcerated. He has contributed to a multitude of reports with organizations including Worth Rises, the Sing Sing Quaker Worship Group, and the National Association of Criminal Defense Lawyers, US. Robert's work with NACDL is specifically focused on the impact of the trial penalty. He's also worked as a research fellow with Columbia University's Center for Justice and as the production manager for the TEDx Sing Sing with the theme of creating healthy communities. Robert has an inherent understanding of mass incarceration and the elements necessary to foster social change through community activism of people directly and indirectly impacted by mass incarceration. He earned a Bachelor of Science degree in 2007 from Mercy College and a Master's of Professional Studies in 2008 from the New York Theological Seminary. And finally, Brian Simmons, and I know a little bit about Brian because my friend Darlene Comstead worked on his case, and we'll come back to that for a second. So shout out to Darlene as well. Brian owned and managed 2 state-permitted medical marijuana operations in Southern Oregon, which were raided by the DEA in November of 2011. Mr. Simmons was indicted 6 months later, charged with 1 count of manufacture, possession, and distribution of a controlled substance. The prosecution offered Mr. Simmons a plea deal of 6 years, but he decided to exercise his right to trial under the 6th Amendment after Mr. Simmons was convicted at trial, the prosecution recommended that he receive 19 years after having offered a 6-year plea offer. And upon reflection, the judge handed down a sentence of 180 months or 15 years. In 2019, Brian submitted an application for commutation to the Office of the Pardon Attorney. Later in 2020, he contacted Professor Jane Ann Murray, who will be moderating our third panel, at the University of Minnesota Law School Clemency Project for help in filing a supplemental motion. Based upon the trial penalty motion, the motion was written by Darlene Comstead and submitted directly to the White House. His petition for commutation of sentence was signed by the president on January 20th, 21. So those are our panelists. It's an honor to speak to the three of you. Let's start. And why don't we start with Ms. McFarland? Can you just introduce yourself and tell us a little bit about your story so that we can all understand where you're coming from?
Yes, thank you, Martín and NACDL for having me. I'm really excited to speak to you all today. As a young student, I majored in journalism, and then I wanted to go to law school, and had a normal life. I practiced, started off with an internship in the Fulton County District Attorney's Office, thought I wanted to be a prosecutor, didn't quite understand the political side of that. And I backed the wrong candidate during an election, and found myself on the outside at that point. And so I decided to do criminal defense lawyer work on the state level. And I did that. I didn't practice on the federal level at all. And then when I had a very complicated pregnancy with my first child, I decided to do transactional law and got into real estate transactions. So this was in 1999 when the housing market was booming across the country. And I didn't know really anything about it. I did buy the program that helps you do the closing documents, and I hired a seasoned paralegal thinking that that was going to be enough. And, you know, I had some attorney mentors that agreed that they would help me. However, it did not prepare me to be victimized by a fraud ring that essentially, with the help of the paralegal that worked for me, they came into my office, and I won't say that I'm not culpable for what happened, because I do take full responsibility as the attorney. However, I trusted her, and I was not aware until a lot of things after I was indicted, and I looked at discovery documents and I saw where my name had been changed, title commitments had been altered, all sorts of awful things that were done. And so I guess mine is a cautionary tale of always be on top of what you're doing, and sometimes flying by the seat of your pants law, which is what a lot of young attorneys practice when they get out, is not a good thing. Because in this case, I hurt myself. But when I go back to when I was practicing criminal defense law, I did a lot of things, and I look back now in hindsight and realize that I could have been much more effective for my clients at that time had I only known more. So given the opportunity today to come in and give you all a little bit of my knowledge on my experience, I'm just very excited to do that.
Chalana, before we go on to Robert and Brian, and this is a question I'll ask of all three, can you help us understand where your mind was at when you made the decision to go to trial rather than accept an offer? What were you thinking? What were the factors that informed your decision? You had legal training, obviously, so your view of it was is probably a very sophisticated view. So let us understand a little bit about what you were thinking in that moment.
Well, I actually believe that my legal knowledge was a hindrance because I did not understand the federal system animal, which is entirely different than the state system. And I had a choice between, you know, it was a Scylla and Charybdis choice. They came and they offered me a plea, which could go anywhere from 15 to 20 years. And as a first-time offender, you know, I was an attorney, I'd never been in any trouble, to be involved in a much larger conspiracy. And then I see where my other co-defendants are being offered 2 and 3 years. it was a very difficult and untenable position to be in. So I felt that I had no choice but to go to trial. I really feel that my trial counsel was a very good man, but grossly unprepared for what we were up against. Because when you battle the government, it truly is a David and Goliath situation, unless you're fortunate enough to have the funds to retain, a larger firm to be able to provide you with those type of resources. But I felt that I didn't have a choice. And then not to mention the things that I was accused of in my indictment weren't true. Was I culpable of some of it? Yes. But did I commit a large range conspiracy with all the things that they put in it? No. And so part of it was a need to want to defend myself and to try to have everyone understand what really happened. So I felt like I wanted my day in court. But in hindsight, I realized that I could have been advised a lot differently and maybe would have had a different outcome, because when I was convicted, the judge sentenced me to 30 years in federal prison.
Ms. McFarland, I want to follow up with a question before we go to Robert and Brian. And the last panel really put the focus on prosecutors and judges where the focus should be, and touched upon the fact that many criminal defense attorneys don't have as much trial experience as we used to in the past, because there are fewer trials, right? Because it's an assembly line system of plea bargaining. Tell us about what you felt about your lawyer being prepared, having sufficient resources or not, whether or not your lawyer had the preparation time and resources necessary to defend you, and how did that factor into your decision?
Well, I actually ended up being represented at trial by a court-appointed attorney after my paid attorney withdrew 4 months before the trial because I didn't have any more money. And so my attorney, court-appointed attorney, stepped in. He literally had his entire basement filled with boxes of discovery. There were hundreds of boxes that the government put on us. And I flew up to Atlanta because I wasn't living in the city at that time, along with another attorney friend of mine who took a leave from his practice, so that we could try to go through the discovery and craft some sort of defense against thousands and thousands of documents that are related to a mortgage fraud case. And my attorney is a solo practitioner. It was, we worked really hard, but we were grossly understaffed and underfunded. We had no experts. He didn't know to ask for experts for forensic accounting and all the different things. And then when we went against the government, they had unlimited resources. And I mean, even something as simple as we had to carry all of our files up to I think we were on the 10th floor of the federal building from the parking down the street, whereas the government just comes in and they roll their little things on the elevator and that's it. And that might sound really trivial, but it's physically taxing. So you're worn out before the judge even comes out, and you're all flustered and you're wondering, did I bring the right box? And sometimes we would discover, oh, we left an exhibit in the car, and we had to send someone down. And I mean, it's very small, but it is very disruptive. And so there was no smooth continuity with preparing for my trial. And even though I was an attorney and my friend was an attorney, we thought that we would be able to do it, but we were grossly unprepared.
Thank you very much. Thank you for sharing that. I'm sorry to hear. I know exactly what you mean, the extra work that is required to be ready to defend when you're bringing all the boxes in every day. You lose a couple hours, and those are valuable hours during trial. One last question before I turn to Robert. Did the court give you paralegals to go through all the boxes and do the work?
No, the court didn't give us anything. And even when my friend asked to come in pro hac vici on the case, the judge said that if I could have him, then he would take away the court-appointed attorney, but that he would allow him as a member of the bar to sit at the table, but he could not participate in any way. So even when I went out and got my own help, my hands were tied.
And this is really my last question for you for now, but you just raised something, and this is probably speculative. Did you have a sense that the judge had an attitude about you deciding to go to trial, or was the judge attitude the same before you decided to go to trial as it was after you decided to go to trial?
No, it was markedly worse after I decided to go to trial. Actually, there was a superseding indictment that was placed upon me after I did not take a plea at the beginning, in which they added, I think the total number of counts that was ultimately added to my indictment was 171 counts. And it was so bad that during voir dire, we had people that actually said that they couldn't be fair and impartial just because of the number of counts, because if I was accused of that much, I must have been guilty of something. And a couple of those people were allowed to be rehabilitated and placed on my jury, but others were excused or stricken. But it was a massive overcharging in my case.
Thank you very much. Robert, let me turn to you. Tell us a little bit about your case, and you could come around. You've mentioned to me before that you had the view that the judge reacted to a series of Batson challenges that your counsel made. And so can you fill us in a little bit on your story and then come around to this issue of your feeling about the judge's reaction to the Batson challenges?
I was convicted and I got arrested in 1992, causing the death of my mom's then boyfriend. He had assaulted her earlier in the day and caused her to be taken to the hospital. At the time, I wasn't home, so I didn't know this had occurred. And then he left, the police came, he left. He came back later that evening with a weapon and was at the house. When I returned home, I discovered him there at the house, and I saw him there on the stoop. And as I approached, I noticed he had a weapon. I stopped, and then I figured, hey, I can get him away from the house to just try to find out what was going on. So I was able to do that, get him away from the house. And at the time, I thought I would just get him away from the house, leave, and go back home to find out what was going on. I pushed him away from me. He turned with the weapon in his hand. I grabbed it. I shot several times, causing his death. I had the belief that he had another weapon. The following morning, this was later that day, rather, because this was early in the morning, I went down to the local precinct. I told them what happened. Obviously, I was arrested and charged with second-degree murder and criminal possession of a weapon. After arraignment, I was granted bail. I was released a few weeks later on bail. And then after that, took about 3 years to go to trial. Once the trial started, it was a lot of hearings and a lot of procedures, things that I didn't know much about. So it was kind of complicated for me at the time.
How old were you at the time, Robert?
I was 19 at the time. And it was my first, I guess it was actually my first touch point to any criminal justice stuff. So I really didn't know a lot of the things that were going on at the time. But at the time I was learning because, I was on bail. So I would meet with the lawyer every couple of weeks. We would meet. And it was pretty much at that time, it was just, I'm going to work on things. And I put in an omnibus motion. We got some discovery, look over it. We would meet again. He would say, how you feeling? Everything's okay with your family? And that was basically our conversations. And then one day we went in for a normal court appearance, and it was a new judge. And she said, we're going to start trial now. It was like 1 o'clock in the afternoon. She called the panel up. They started picking a jury.
Robert, you didn't know it was scheduled for trial that day?
No, there was no schedule because the judge that I had was on trial with another case, and it was going to be wait till that trial finish. And for some reason, the DA requested that we be transferred to another part. And when he made that request, obviously it was granted and we were transferred to another part. And that judge decided to start the trial that very day. And it was late in the day because they call it second call, where they call you back for the second calendar call. And she picked the jury, we started picking the jury. And the trial attorney at the time made a lot of objections to the process of how the DA was using his preemptory challenges, and they had lengthy hearings about it. And I think the judge at the point got kind of aggravated as a result of all the challenges that the attorney was making. And once it got to a point where I believe he proved that some of the challenges were pretextual and showed that, I think the judge got really mad and just said, listen, I'm not going along with this, stop. And then she called the
Robert,
lawyers.
we're talking about challenges to the prosecutor's use of peremptory challenges based on race. And your lawyer was litigating this, and the judge, you're talking about the judge's reaction to this, right?
Yes. And so the judge got very, I guess she was very agitated. And at the time, she just stopped everything at that point. And she called the prosecutor and the defense attorney to the back. They talked for a while. They came back out, and she just said, I warned both of you, I'm not going to tolerate it anymore. So at the end of that point, they made a plea offer of 5 to 15 years. And at the time, after speaking to the lawyer, he says, well, we don't know what's going to happen, so let's just wait. And then nothing really happened. We went to trial, a series of more hearings, and after the conclusion of the people's case, the trial attorney, the judge and the DA said, hey, we'll offer 3 to 9 years. At the time, I didn't take the 3 to 9 years. I went to trial. After the conviction, the judge sentenced me to 25 years to life. And at the time, I served 24 and a half years. I was released October of 2019 after serving 24 and a half years of the 25 to life sentence. And I would say it was basically, I think she was angry about some of the challenges in the hearings, and just that maybe because I didn't take the plea at the time, and it was just something I didn't know. And when speaking with, an attorney to tell you, hey, listen, 3 to years, 5 to 15 years, and then it was never a talk of, a life sentence or 25 to life. That was something I didn't really realize until after the conviction, that it was that much of a sentence, because initially I thought it was like 5 to 15 years. I never knew it was that much. And it was a lot to learn, right after conviction, that you can get up to 25 years. And unfortunately, that's what she did at sentencing.
Robert, take us back to the moment, just as I asked Chalana before, when you decided not to take the 3 to 9. What were the most important factors that informed that decision for you?
One, I thought that based upon the DA's assessment, is that the guy, my mom's old boyfriend came to the house. He had the gun. It wasn't my gun. It was his gun. The DA knew that. He said, hey, we know you didn't have a gun. We know you didn't initiate anything. However, this is what it is. And so it was my opinion that I believed I was justified in my actions, and that everything that I did was justified because I didn't cause the problem. I wasn't the initiator of anything. So I thought I was okay. So I went on, I said, you know what? I'm not going to try to take a plea because, I think I was right. And I just went on to trial and kept on going with the process.
Thank you very much, Robert. Appreciate you sharing all that with us. Brian, may I turn to you and ask you to please introduce your story a little bit, and then I'm going to ask you the same question about that decision moment for you.
Okay. Well, my story is I was a marijuana grower in Southern Oregon. Like you said, I had a couple of farms. They were state permitted farms, but of course, under federal law, marijuana is still highly illegal today. At the time, I kind of caught the tail end of busts that were going on in Oregon and California with the DEA. They're still busting people today, of course, but not like they were. But I kind of caught the tail end of the busts and got busted at the end of 2011. They waited about 6 months to indict. And then when they did indict, I had a court-appointed attorney. I didn't have enough money to afford, hiring an attorney. So court-appointed attorney, local.
And Brian, why was that? You had these farms. What was it? Could you leverage the farms? Could you get loans?
No, I had At the time, I owned 3 pieces of real estate, but they were all financed owner contract things. I ended up having to give those back to their previous owners. We had put the farm that I had that year, we had pretty much put all of our money into development of the farm. So we were really running a very tight budget. And the DEA, they bust people at the end of the year, in these marijuana cases. And that's because they know that you've put, as much money as you're going to put into it. So they get you as bad as they can, so they, came on the property, stole everything. I say stole. That's kind of how I see it, but they took everything. And so I had no money to, defend myself in any way, had to go with a court-appointed attorney. And to answer your question about going to trial, it came down to that decision for me. As you said, I got a 6-year offer from the prosecution, but that offer, of course, came with some strings. And one of those strings was full disclosure. So I had about 13 employees on my larger farm. And there were a few people that were involved in different ways, not in sales of product, but in doing other things at the farm, which may or may not have gotten them in some trouble. And the prosecutor, of course, wanted to sit me down and ask me questions about everybody else, because they picked up a couple of people who were involved with the farm, but not nearly everybody. We were lucky in that we had some forewarning that this bust may happen. So at the time that the bust happened, everybody was, I had told everybody, hey, it's probably time for you guys to get out, and so that was a good thing. It saved a lot of people having to go through a lot of trouble. But I was unwilling to disclose anything about anyone else. I wouldn't have felt that that was right to get anybody else in trouble for marijuana. I can't fathom that. I wouldn't be able to live with myself for that. So I asked the attorney, I said, well, if we go to trial and I lose, which of course was almost inevitable, I said, what do you think I'll get? And he said, I don't think you'll get more than 7 or 8 years based on the climate of marijuana. And so I said, okay, well, let's roll the dice then, and go for that. And so we did. And then after the trial, the prosecution asked for 19 years, which was what the guidelines stated for the amount that they had seized. It was a real shock to me. I had never been through this before. I knew nothing about the federal system and what happened. So when they're offering 6 years and my attorney's saying, oh yeah, probably not more than 7 or 8, hearing all of a sudden the prosecution stand up and say, yes, we'd like to have, 19 years. It's like, what? And then the judge, said, okay, you got 180 months. And yeah, that was a real shock for myself and for everybody else in the courtroom too.
I can imagine. Brian, going back to this issue of full disclosure, as you described it, if I just understand correctly, you were offered 6 years, but that required naming other people who could then be prosecuted as well, right?
Yes. Yes.
And did your lawyer go back to the government and say, he'll take the 6, but he won't name any names? And the government said no to that, or did you just not pursue that?
I don't think that happened. He told me that, disclosure would be required. And I said, I'm not going to do that. Got
it. And so how would you describe your relationship with your attorney, and how did that factor into your decision to go to trial or not go to trial? In your case, to go to trial?
Well, it really didn't factor in. My attorney was a fine attorney, and he did a good job as best he could. I think he went into it with the mentality of knowing that he was probably going to lose, which I can understand because, hey, I was guilty of the federal crime of growing and distributing marijuana. So what are you going to do, But he wasn't a trial attorney. I can say. He didn't have the charisma quite that some other attorneys had in there for some of my co-defendants. But that wasn't really the factor. The whole thing about it was that I was not willing to help the prosecution in prosecuting other people for marijuana.
So thank you, Brian, and thank you, Robert, and thank you, Chalana, for that overview. In your view, and this is a question to all three of you, understanding and looking back on your decision making, what would have been necessary for you to have made the best decision possible, and what would you change in the process to make it more, just a little bit more fair, or a lot more fair, if you can pinpoint one thing?
Well, as far as I'm concerned, I mean, fair is a judgment call. Some people may think that what I was sentenced to is fair. They may think that marijuana is a scourge and I'm an awful person for, even being involved with it. Never my experience in marijuana, of course. It was a great community of people, positive, intelligent. I loved it. And, we'll continue to look back on that as a good experience. And of course, still have friends today who I knew then. But in my opinion, a first-time offender for marijuana, even in 2011, 2012, just didn't warrant a sentence of 15 years. There's just no way. I mean, putting me in prison for any amount of time didn't do anybody any good. It's just a fact that I know myself. So the other thing that I could say is that my attorney didn't inform me of what the maximum penalty could have been. And I didn't ask, being, uninformed on those issues of federal prosecution and how the sentencing guidelines are set up. And having said that, I still wouldn't have changed my decision. I mean, he could have said to me, "You're going to get life in prison." I would have said, "Okay," because I wasn't going to throw my friends under the bus. There was no way.
Thank you, Brian. Robert, what would you change looking back on the moment that you made the decision? What would you change to make the system just a little bit more fair?
Looking back, I would really want a lot of clarity. Like, I guess with any defendant, if you've never been involved with the criminal justice system, you should really have a better understanding of what the whole process is. I think maybe the judge should really try to have it explained to you, or tell your lawyer to explain it to you, which I've learned that is the process, or should be the process. But it should really be made clear to you and your family who's there, because a lot of times it's a big decision you have to make. And at the time I was younger and I didn't really understand everything that was going on. So I think it would have been great to have my family involved and know more of what was going on in the process than it just being upon me to make those big decisions and try to figure it out on my own. And I know the DA at the time said that, he stood up in court and said, "Hey, I wasn't a normal defendant. I was different. I'd never been arrested, that I was doing some things." The DA said these things about me, and then you still turn around and argue for the maximum sentence. So it's like, they're speaking two different things at one time. And it's really confusing, because you hear him saying these things and then he switches and you say, "Oh, give him the max." And then the judge says the same thing and you get the max. So it's really weird, and I really think if they make an offer, they never should be able to go higher than the offer, or maybe whatever the minimum is. It should stay around there. And then I think that there should be some kind of check for, even with the legislative, because I know the sentences are based upon what the legislators put out. I think something should be done to just say, "Hey, first offender, second offender," some level of mitigation to find out what went on, and have a crime that fits. Because like you say, a person with a non-violent crime and a violent crime, it's really weird. I committed a crime. I know it. I did something. I caused someone death. I'm responsible for that. But I'm not saying that I shouldn't have been punished. I just think it was over punishment, because, I didn't do everything that they thought I did or didn't do. I just think it was over a lot, And during my time in prison, I discovered a lot of people that did very little and people that did a lot. And it just doesn't make sense. The system needs some work. What could be done to fix it? I don't know. And if I had to make the decision again, would I go to trial? Knowing what I know now, I probably would plead guilty. And even if I had to recommend it to someone, I would say, hey, these people can take your life away. You may have to just plead guilty and move on with your life. You know, even though you may be right, you know, it's a scary thing to know that they could just take your life away because they're angry at you, or you know, because you decided to go to trial. You know, it's a lot that a person has to consider, and it's just scary. It's really scary.
Especially at 19, 20 years old. Let me ask you a quick follow-up before we turn to Chalana on this. Did you feel that your lawyer had enough time for you, or do you feel that your lawyer had so much other work that he or she didn't really have enough time to discuss these things with you? Or do you feel that you were too young to process these things? Where was your head at?
Well, at the time, he was what I would say a working attorney in the Queens courthouse. He was in the courthouse maybe 5 days out of the week working 2 or 3 different trials. So maybe he didn't have time for my case. And what I've learned later was most of his cases, like you said earlier, went to plea. So it wasn't a lot of trial preparation. You go in, you work a deal with the district attorney, and you move on. I guess in my instance, it wasn't that. It was more of a preparation for a trial. And I don't believe he was really prepared for a trial, because the judge just sprang it on us one day, and you know, it was trial time. And I think he tried to use a lot of his experience as, I guess, a trial lawyer, just being active in the Queens County Court to help him along the way. But things happened really fast, and he tried to do the best he could at the time. And I think he got overwhelmed and just didn't do, you know, everything, didn't have the time to explain things to me. You know, it was just not, you know, it just happened very fast. And then, you know, it wasn't a court-appointed lawyer. You know, my family paid him. I paid him a lot of money too. And it was, you know, when you pay people, you think you should get better service and they should really explain things to you, but it wasn't. You know, it was just, he caught me at the right time, my family at the right time, and told them a story, and they believed him, and it just didn't work out for me, you know.
Thank you, Robert. Chalana, back to you on this question of what would be the one thing that you, looking back on your experience, that you think could be changed that would be helpful in terms of reducing or eliminating the trial time?
I think that, well, there are several things, not just one thing. I think there needs to be adequate trial preparation and resources available to defense counsel that somewhat evens the playing field. I think they need to have unfettered access to experts, just like the government does, who has unlimited resources. I also think that there needs to be more support for trial attorneys from the defense bar, so that they can eliminate the fear of retaliation that from the judges. A lot of times there's a fear, like if I really push on this issue, then, you know, I've got other cases pending before this judge, or if I'm court appointed, this judge may not appoint me any more cases if he thinks I'm being difficult and I don't want to play ball. So they've got a financial concern. There's also the same issues somewhat with the prosecutors, where you want to go in and you want to be able to, you know, have a good rapport with the prosecutor so that they can offer your clients the best deals. And because of that, you don't want to tick them off. And so my attorney, many times during our negotiations, would say to me, Chalana, look, we don't want to make them mad. You know, we just have to let this point go. And I didn't think that there were several points that should have been let go. I also feel that as the attorney, I would encourage you to actually listen to your client. We actually know our cases better than anyone else, and particularly when it involves an area that you're not familiar with. For instance, whether it's real estate or marijuana growing or whatever, let us kind of train you on what we need, or give you a semblance of an understanding of that area, and then call it an expert if you still don't understand it. But to just gloss over things, it does a disservice to your trial preparation and to your client. And also, I would say that there needs to be CLEs or organizations to provide litigation training to solo practitioners and smaller firms that are done by seasoned attorneys, or perhaps there should be an ability to partner with larger firms when you land a big fish case and you don't know what to do with it and you don't have the resources. So there should be more mentoring going on. There should be more seasoned attorneys that you can pick up the phone and call and say, hey, listen, I have this and I don't have a clue what to do with it. This is what they're saying. Do you have any advice for me? And so I think there needs to be a better network of availability for attorneys to reach out when they need help. But and I think that the judges really should not abuse their power from the bench, with being so intimidating. It really should be an even playing field, but I don't know that that will ever happen.
Brian, you're shaking your head. Yes, let's pick up on this theme that has come across both with Robert and with Chalana, and that is this notion of evening the playing field. Was that a factor in your situation as well, Brian?
Well, I remember speaking to my attorney about that sort of thing, just looking at the relationships between the defense attorney, the prosecution, and the judge. I remember him saying to me, hey, they hold all the cards. They've got all the power. They've got the backing of the federal government, all the money. They can do whatever they need to do. And they've got the ear of the judge. The judge is definitely more deferent to the prosecution than they are to the defense. Also, one thing that happened to me was a second attorney that I had. He was a good negotiator, and his kind of claim to fame was that he negotiated good deals. And had a good relationship with the prosecutor. And so I understand that how important that relationship is for the defense attorney to have a good relationship with the prosecutor, to not piss them off, because they need to be able to, these guys work together every day. The client, they're in and out, in a few months, and then there's the next client. But these defense attorneys and prosecuting attorneys, they work together for years. And so they need to have that kind of working relationship. So that's understandable. It's not a level playing field. It's just not when they're standing up there in front of the judge. The judge is more deferent to the prosecution. And I think that's in general, that's probably true. You certainly would know more about that than I being in that world. But that appears
Brian,
to be the case.
Were you on pretrial release?
I was. Yep, I was released without bail. I was nonviolent, first-time offender, no guns involved in the case. So I was released.
Chalana, were you on release?
I was on pretrial release for almost a year, or a little over a year. And interestingly enough, when I was convicted, I was immediately taken into custody. I wasn't allowed to self-surrender, even though my lawyer had told me. I even flew in. I was living in South Florida at the time, and my case was in Atlanta. And I made even the pre-trial status conferences hearings where I was in court for 5 minutes. I've made every one. And suddenly, once convicted, I was suddenly a flight risk. And the justification that the prosecutor used at that time was that I had traveled outside of the country several times over the last 5 years, even though my stamps were for the Bahamas and Jamaica, and it was for vacation, and I had already surrendered my passport. So I suffered the additional penalty of being taken immediately into custody. And at that time, I had a 3-year-old daughter, and she was at the babysitter that day, and I didn't even have, I was trying to yell to my parents to be sure to go get the baby, because they're crying, everyone's crying about what's going on. And all I can think is, who's going to pick up my child? And they didn't even give me a chance to talk to my family to arrange anything as far as childcare. I didn't get to pack out my house I didn't get to do anything. They took me straight to the jail. And it was totally unwarranted. And I feel that it was retaliatory for going to trial.
Thank you, Chalana. And Robert, given the charges in your case, I think I know the answer, but were you on pretrial release?
So I was released to bail, which a lot of attorneys thought was really weird because normally homicide-related offenses never get bail in New York City. And the judge that I had in Queens County, a lot of the lawyers said he was probably one of the worst judges they ever came before. And for him to give me bail, they thought it was extremely uncharacteristic of him, as well as something was going on. And I was out for 3 years, a little over 3 years, 3.5 years. And I made every court appearance. I showed up when they told me to show up, and it was fine. After I was convicted, I was remanded, and then I was sentenced 30 days later. But you know, it was just different, you know. But I was out for 3.5 years.
Thank you. And there are studies. I'm a little surprised. I did not know you had been released, Robert. But it makes sense that people who are on release are more likely to go to trial. There's studies, there's a lot of work that shows that people who are held in pretrial detention are much more likely to break down, feel unconnected, feel isolated, not have access to their lawyers, not have access to their support systems, their families, friends, et cetera, and much more likely to take a plea, even if they felt or feel that they're not guilty. So it makes sense that the three of you were on release, and that probably played into your role, I would imagine, to go to trial. Now, let me ask you a question that came up during the last panel and a little bit in this panel, and that is the notion that there should be some relationship between a pretrial offer and a post-trial sentence, that there's some proportionality there. It's something that people have talked about. On the positive side, it can cap or limit how much the prosecution can go up. On the negative side, it could end up encouraging prosecutors to raise the boat, that is, increase pretrial offers so that they have more latitude post-trial. What do the three of you think about that? Would that have affected your situation at all if the offer had been a little bit higher, or really wouldn't have had an impact on you folks? Let's start with you, Brian.
Well, as I said, I guess with the full disclosure requirement, it wouldn't have had an impact. I would have had to have done the same thing. But the thought that occurs to me when we're talking about that, the post-trial sentencing being closer to what any pretrial offer might be, that really makes sense to me. It's so shocking that, I mean, they're supposed to be offering you a sentence. You're supposed to receive a sentence based on, am I saying this right, 3553A factors? Is
Yes.
that correct? Yeah. Yes. And those factors, so those factors are several factors in there of, not repeating the offense and this sort of thing and teaching you your lesson or whatever. And it seems to me that if a prosecutor is going to offer somebody something, and say they offer me 6 years, that if that is sufficient to serve those factors of justice, then the same should apply at the end of trial. Otherwise, it's pretty obvious that you are just being penalized for going to trial, because frankly, they don't want to do the work. They don't have time, to do all this work to prosecute everybody in a trial. They just want to get it done. And so, they're offering a lot less in order for that to happen. But if it's really about justice and not just about, how much time they have and how many prosecutions they want to get through that year and how many years of jail time they want to give out, then it should be fair. And if 6 years is an offer at first where, that serves the interests of justice, then it should also serve the interests of justice at the end of the trial. And the prosecution is who needs to live up to that obligation, I think,
Thank you, Brian. Robert?
Yes, I know here in New York, they just had the elections for most of the district attorneys. And one of the things that they said during their campaign is that they would tell their prosecutors not to overcharge cases. So that would actually help. So if a case was determined to be a murder or manslaughter, it would have a difference. So these are things that I know now. You know, murder, you can get up to 25 years to life in New York. On the low end, you can get 5 to 15 years. So that's something that I know now. And if it was, let's say, manslaughter, you could get as low as 3 to 9 years on no jail time at all. So if when they get all the facts initially with the police and their investigation, and they determine that a case should be, let's say, manslaughter, they shouldn't charge murder and manslaughter together. And then when you go to the charge conference and the judge charge you with murder, manslaughter, depraved indifference, and they come up with all these different things. So that becomes very confusing because you're like, where did all this stuff come from? You know, it's a lot of stuff to consider. And I think it should be one thing, you know, it's like what Brian said, you know, if they offer me 3 to 9, how can I go from 3 to 9 to 25 years to life? You know, if the DA thought at the time and the judge that serving 3 to 9 years was enough for my actions, then what made it change? And actually 2 days, you know, what changed in 2 days, you know? It's kind of hard to figure out what changed in 2 days to make it go from that to that, you know. It's so I really think whatever's offered should stick, and it should be some new legislation to allow for, if an offer is given, then they could depart from whatever the mandatory minimum would require. So that would allow judges to give you something, you know, less than what the mandatory minimum may state, you know. Thank you.
Thank you. Chalana?
Well, I think that there are a number of things that need to be evaluated. One is alternative forms of incarceration. That could be something that could be put on the table, especially for first-time offenders, where you may decide not to go to trial if you could serve your sentence on home confinement or an ankle monitor. But definitely the sentence needs to fit the crime, and it needs to be based upon culpability and not who got to the district attorney or to the prosecutor first to get the best deal. And it should not be based upon those type of factors. And it's wrong because usually the person that has the least amount of culpability ends up with the most time because they don't have anything to tell or cooperate with. And then the people that do the most are able to help prosecution with much more. And so their time is significantly cut. There are 2 people that I'm advocating for now. Kim Robinson, she was a delivery driver in a federal case, and she ends up with a 25-year sentence, whereas the guy and his mother that she was currying for received 6 years. And then Terrence Cole, his connect, it was a drug case. His connect out of the Dominican Republic received no jail time and was deported back to the DR, and he receives 2 life sentences. There's something fundamentally wrong with the art of the deal when it comes to how prosecutors hold time over people's heads to be able to make cases. And until that's unraveled, I don't know that a cap would have any relevant significance in being able to prevent people from having to take deals and be able to execute their constitutional right to a trial.
And thank you. A question for Robert and Chalana principally. Brian, you're free to weigh in, of course. Do you folks?
Can I make a comment about that?
Yes.
And I had a similar experience also. Yeah, I had an equally culpable co-defendant, older than me, business partner, who was also involved in the farms, and same, first time offender, all of that. He was sentenced to 1.5 years. And the difference, he cooperated. He was the prosecution's witness.
Got it. Chalana and Robert, what role do you feel that race played a role? And if so, what role did race play in your situations, in your decision-making and in the outcome?
I didn't feel that initially that race played a part. I thought the judge just hated me. And but then maybe 2 years after my case, same judge, same prosecutor, same charge of scheme with mortgage fraud, with flipping properties. 2 male white attorneys were sentenced, and my loss amount, which of course for those of you that practice federal law knows that it contributes to your guideline range. But my loss amount was $11 million. These gentlemen had losses ranging from 15 to 20 million. One received 33 months and the other received 42 months. On a plea, true
Same
enough.
judge, same judge?
Same judge, same prosecutor, same scheme. And so at that point, I said, well, let's line up the differences and see what's going on. And these were both seasoned attorneys. They would have been practicing for a number of years. I was relatively a new attorney. I was just barred in 1996, and my charges, my indictments span from 1999 to 2001. So we're talking about someone that's, fresh out of law school, as opposed to someone who's been practicing for 10, 15, 20 years. So when I lined up the 2 cases, the only thing that I could see was, I am an African-American woman, and I don't know what else was the difference. And if they had come to me and said, well, hey, we'll offer you 33 months or we'll offer you 42 months, that may have been something I would have considered. But like I said, they came and said, well, we could look at 20 years and that was just not even something that I could fathom at that time as a mom. You mean my daughter will be 23 before I could even come home? As it turned out, she was 21 when I finally did come home. But it was just, it's still very much surreal when I look at my case. Very much so.
Chalana, it's just so painful to hear. I know that my apology on behalf of everything is just, it doesn't help, but it's just so painful to hear. I'm so sorry, particularly what you've just told us about the comparison with these other folks who went through the process later. I'm speechless. It's very painful to hear. Robert, I'm sorry, go ahead, Chalana.
No, I was just going to say, Martín, in addition to that, I basically have a life sentence because for the next 20 and then possibly renewed for another 20, I have this judgment hanging over my head, which now with interest is now 15, almost $16 million that I have to pay every month for restitution to financial institutions that entered into a settlement with the government, and many of them have already folded. But I pay every month for my restitution. So it's an additional penalty and it's a judgment. So it prevents me from even being able to have any assets or ever buy a home. So it is a never-ending cycle. I thought when I received clemency from President Trump that this was going to be the end of my troubles, only to find out, no, they continue.
Sorry to hear that. Robert, back to you on the question of race, and then Brian, I'm going to give you the last word because we're already at the end of the hour. So Robert, do you want to weigh in on the question of whether or not race had an impact, played any role in your process, either in your decision-making or in the process?
Well, for me, like I said, at the time, I really didn't know a lot about the criminal justice system or how race played a role in the legal system here in New York. It's like, even when I mentioned like they had the Batson challenges and all those issues, I didn't understand what that was at the time. I knew later, like after conviction and when I was transferred to a state facility, and I had a chance to read different cases in the books, and I started discovering what Batson was, why I was in the position that I was. So then I discovered that, yeah, race did have a role to do with it. But initially, I just thought I was going through a process, so it took a lot of years to read and understand all the things that I went through. And then as I learned, I was able to, advocate for myself and work toward, freeing myself from prison, because I had a life term and I could have still been in prison, but I had to work toward getting out. And it's a lot of work. And throughout the time, you discover that race plays a heavy role in New York when it comes to convictions, as well as getting out on parole and other things. So it's something you have to really focus on, and clients should be very much aware of that before and making their decisions. It should be talked about.
Let me ask you a real practitioner question on that. Like, let's say you and I are in a room and you're giving me advice, I'm your client, and and race is going to be an issue, and what do you say to a client, about that? Do you say, look, you got to take into account the fact that the system is profoundly racist and that's going to hurt you? How can a lawyer communicate that to a client? And I think a lawyer has to be completely transparent and open about this with a client. But how do you transmit that to a client without sending the message, I don't want you to go to trial because it's a racist system?
I think being very honest and very clear. You tell your client, hey, listen, you're a Black guy, you're in this courtroom, you got an all-white jury, you got a white judge, you got a white prosecutor. You may get life in prison. You just have to be honest with them. That's what I discovered Batson was about, taking off all the people on your jury of your race alike. They got them off. And so as a result of that, they stacked the jury for a certain way. These are things I didn't understand at the time, and in New York, most Black people don't participate in jury duty, so they're not there anyway. So when you get a few, you have to be thankful that you got a few that may, have a side with you. But then race shouldn't be a matter anyway if, you're going to go by the law or what have you, but that doesn't really exist. People make up their own mind when they walk in there, I discovered. They make up their mind, they're going to find you guilty, they're going to find you innocent or what have you. The lawyer just has to tell the client, listen, man, this is what it is. You're Black or you're Latino, whatever. You have to tell them you have a choice of, a chance of getting a life sentence, And over the years, doing a comparison of other cases, I could say similar to my own, and looking at the sentences, you saw a difference. There was a disparate treatment between defendants, between counties, cases that were in New York City area and cases that were upstate, there was a difference. And you saw it. So I think any lawyer should be very honest and very clear with the client and tell them right away, don't mess around with these people. They'll give you a lot of time. If the lawyer truly believes, he should just tell them. They'll mess your life up.
I understand what you're saying, and I agree with the transparency. Let me tell you, having been there as a lawyer, it feels like you're putting pressure on your client to plead when that's not really what you want to do. It's a really difficult place to be. And I've gone head to head with judges on this issue because we do need to be completely honest with our clients and completely transparent. So Brian, I'm going to give you the last word here, and then I'm going to wrap up because we're already at the end of the hour. Is there anything you want to add here at the end?
Well, has me thinking about the racial issue, and being white myself, I can't say that I know so much about that, having not really experienced that. When Robert was talking about, how you're asking him how would you have a lawyer inform them of this? I agree that people should be informed of it, if that is the case. At the same time, I guess you have to deal with it in a practical way. The system is what it is, and you're not going to change everybody's minds overnight. It's going to take a long time. I guess it's been, over 100 years in coming already, and still hasn't, come as far as it needs to. So at the same time, you're going to have to be honest with, how you would advise them. Just like now, even though we know that the trial penalty isn't right, it exists. And so I'm sure that, most defense lawyers will continue to advise their clients to plea.
Well, it does make you feel like you're a tool when you're of the system, when you're communicating this to your client. And so yeah. It is, from an ethical point of view and a human point of view, it's obviously hard on the lawyers. I don't mean to say at all that it is as hard on the lawyers as it is on the clients. That would be ridiculous. And it's time for me to wrap up. So I want to wrap up on this point. I am just so moved by your stories. Thank you for sharing them. I am so sorry that you've gone through what you've gone through. It is a really important reminder for us so that we roll up our sleeves and we really lean into this problem, not only to prevent future people from being in the situation that you've been in, but to reach a hand back to people who are still languishing in prisons now because of the trial penalty. So Nora Zimmerman has been kind enough to put all the contact information for you folks into the chat. Anybody who wants to reach out to these folks, please do. You can hear how valuable and inspiring their stories are. So on behalf of NACDL and also personally, thank you, Brian. Thank you, Chalana, and thank you, Robert, for sharing your stories and being with us. Monica, thank you.
Thank you. Can I say real quick, I would welcome any communication from anybody because I am definitely willing to help in any way I can for justice reform. So please reach out if there's anything I can do.